First case, IRM Holdings versus International Reinsurance.
Testing. Working. Good morning, Your Honor. It pleases the court. Thank you. Welcome, everybody. This case arises from a breach of contract action in which a defendant made a counterclaim for breach of contract, and in that counterclaim brought in a new party, a foreign corporation named IRM Holdings Limited. My name is Jeff Cutler in the lower court, and in this court I represent IRM Holdings Limited.
What's your name in the upper court?
Yes, in the upper court. So, in any event, very briefly, IRM, which is a Florida corporation, actually known as International Reinsurance Inc., acronym IRM, often used in the pleadings, filed a lawsuit against IRP, the appellee in this case, and the defendant in the lower court, alleging unjust enrichment and constructive trust for monies that were transferred from IRM to IRP by the president at the time of IRM. The transfer, according to the directors of IRM later, was improper, and that gave rise to the lawsuit, the underlying lawsuit.
The way I teach this issue with my students is there's a two-pronged test. We have the statutory and then the constitutional on the Venetian salami.
Yes.
Can you address their argument that the first basis is a breach of contract that had to be performed in Florida?
Absolutely. The appellant's position is that the two-pronged test has not been satisfied. It wasn't properly pled, and it wasn't proven. On the allegation of breach of contract, as we know, there are to the two prongs, and yes, the Florida long-arm statute says if you can plead and prove a breach of contract in Florida, you satisfied the first prong. The second prong of the 14th Amendment allows for due process, constitutional due process, requires a finding of minimum contacts. And we know that they've made the allegation of breach of contract. We recognize that. It is the second prong that the appellant believes was not satisfied by virtue of the...
You concede that the first prong was satisfied?
Only by virtue of the allegation. Of course, it's going to be a challenge one, but we're not there yet. We're only at the challenge of
you could have
jurisdiction.
You could have challenged it by filing affidavits saying that you have done nothing in Florida.
No, we did do that. I apologize. A motion to dismiss was filed with supporting affidavits.
Okay.
And those
the Venetian salami, if the affidavits cannot be reconciled, you need an evidentiary hearing. Did they have an evidentiary hearing?
There was an evidentiary hearing, and the burden shifted, as the court is clearly pointing out, to the plaintiff to prove personal jurisdiction of my client.
All right. What is it? There's a written contract that calls for IRM Holdings to do something in Florida.
To make a payment. The question of whether it's in Florida is not explicit.
Is the payment something that you admit that has to be made, or one that if they prevail on the merits of the lawsuit, you would have to make?
Only if they prevail at trial, Your Honor.
Okay.
Let me ask you a question. The very first part of Venetian salami on the pleadings, it's your position that the pleadings do meet the qualifications?
Actually, we raised at the lower court and we raised in the appeal that the pleadings did not actually raise it. They don't allege, and specifically a breach of contract in Florida. It's implied in the pleadings, but I don't believe it.
Is implied enough?
No, not really. Not according to the law. The case one of the cases that I rely on actually discusses that very point, and the appellate court, in this Gadia case, and the appellate court actually says what I'm just saying now. It says, look, they didn't really plead it right, but they had the opportunity, not only in the briefing at the lower court level, but at an evidentiary hearing, to prove personal jurisdiction, and they failed to do so.
If
and I'm
this
actually...
Case, Mr. Cutler, if this case is reversed for improper pleading, it's a pure victory for you, is it not?
I believe, Your Honor, that they've had the opportunity, they were given the opportunity to prove personal jurisdiction, and therefore this court should reverse and grant the motion to dismiss.
On behalf of your client, you filed the motion to dismiss for lack of personal jurisdiction under the Florida rules, correct?
Yes, Your Honor.
And you had the burden of proof of going forward, at least, correct?
I had the initial burden, which was shifted to the plaintiff.
And did
I believe no, because it was raised as a pleading, at the pleading level, it was raised in my motion to dismiss, yes, but not as far as the affidavit goes. The affidavit only went to whether or not there was minimum context here.
To the minimum contacts issue, which, as you pointed out, is the United States constitutional issue under the 14th Amendment, correct?
Yes.
What is the lead case on that subject under federal law?
Well, International Shoe, Worldwide Volkswagen, these are some federal cases.
The initial case, the lead case
Okay.
in the area is International Shoe versus Washington, correct?
I agree with you.
And what are the facts of International Shoe versus Washington?
I can't tell them to you specifically, only that I know that the issue of minimum contacts was addressed and that the...
Probably studied at the first year law school.
I did it.
As did.
I did. That was
International Shoe still good law?
1982. I believe it is.
About 1949, 50, somewhere back in there.
Yes.
It's a tax case, is it not? You remember
Yes.
that?
I remember very vaguely, but yes,
It was
I
an
admit that.
unemployment tax case in which, if I recall correctly, having studied it a few years back, the state of Washington Department of Revenue, or whatever the equivalent is out there, sought to tax International Shoe Corporation, which was not headquartered in Washington, for unemployment taxation, correct?
I remember vaguely.
All right.
I'll accept your representation, Your Honor.
And what did the Supreme Court hold? Let's get to the...
Well, I believe the Supreme Court held that they had to have, I believe it comes down to factors indicating minimum contacts within the state.
And the court held, therefore.
That there was no personal jurisdiction because they didn't have minimum contacts.
Okay, so International Shoe Corporation won, and that's really the issue that you raise here on the merits, if you wish to call it that, the evidentiary side of things, as distinguished from the pleading side of things, correct?
Yes, Your Honor.
And
Of course,
why do you say
Oh.
that IRM Holdings Limited cannot be hailed into court in Florida?
Why hasn't the plaintiff proven personal jurisdiction?
Yes,
And that
cannot not be hailed into court. That's the language of International Shoe, if I recall correctly.
because it lacks the minimum contacts as required under the 14th Amendment.
What contacts are there?
The alleged contacts by the plaintiff in this case is that IRM Holdings had numerous and sufficient contacts in Florida. They allege.
Well, Mr. Cutler, on the facts of this case, am I not correct that the plaintiff, or counter-plaintiff, I guess it is, counter-plaintiff, alleges that IRM Holdings appointed the directors of IRM management, and that that's one ground, and secondly, that those directors actually controlled IRM, and thirdly, that IRM Holdings was obligated to make a payment under a separate contract to IRP, I believe it was, here in Florida. If all of that is true, we affirm, do we not?
No, Your Honor. First of all, on the first two factors, it is understood under Florida law, and I believe in other states as well, that simply having directors on a board of directors.
I posited, Mr. Cutler, the argument that I think IRP will make, that IRM's corporate business was actually controlled by and operated by IRM Holdings, the Caicos and Turks Company.
Right. The
If
issue.
that were true,
Oh.
we would affirm, correct?
I believe if it is significant control as required by Florida law, yes.
And you just
Day-to-day operations.
say there's no evidence of that.
Not only is there no evidence, but the IRP's own president testified at deposition and at the hearing, and it's cited in my brief specifically that he operated the day-to-day activities of IRM and not the board of directors.
There is
There was
evidence.
a conflict, though. There was a conflict in that testimony, correct?
I don't believe so. Not on that issue.
Mr. Alex, you in his deposition, the judge relied on, you would agree, would you not, that IRM Holdings does in fact directly control the business activities of IRM? The answer was, when you say that at a broad level, yes. So don't you have a little bit of conflict in that?
I don't believe so. Although you cite one factor, if you read the deposition of Mr. Lexio, it makes it quite clear.
Well, I was citing what the court relied on, apparently, because
Yeah.
that was the court's dicta that the court was saying.
I don't believe that there is, even though he makes that statement, that if you read his deposition in context and you hear the testimony at deposition and at the hearing of Mr. Santiago, who was the former president of IRM and the president of IRP, that factor is not relevant.
Mr. Santiago also said he controlled the day-to-day operation.
More than once.
More than once. But, as Judge Shepard said, the board of directors, the four of them were appointed by or part of IRM Holdings, and there was a question of how much control they actually had.
Right. As I point out in my reply brief, actually, the proposition that somehow IRM Holdings appointed all the board members and therefore controlled the board and therefore that creates personal jurisdiction is just wrong factually and legally. First of all, the corporate documents call for 5 directors. For whatever reason, there was only 4. 2 of them were appointed by IRM Holdings and 2 of them were appointed by IRP. And so therefore, there was a 50-50 split on the board of directors of IRM. And therefore, you could argue by definition, nobody controlled the board.
All right,
of IRM.
I know you're enjoying yourself immensely, but your time is up. We'll give you a minute for rebuttal.
Thank you, Your Honor.
Thank you. You don't have to lean over.
It'll capture.
Yep.
Good morning.
Morning.
May it please the court. Benjamin Brodsky on behalf of Appellate IRP. Judge Shepard, I think you nailed it right on the head here when you said that this is about due process. And
Well, let's, before we get to due process, can you humor me and start with the first prong?
Absolutely. Your Honor, the first prong of the specific personal jurisdiction test asks whether Florida's long-arm statute has been satisfied.
You've alleged that it's a breach of contract that had to be performed in Florida.
Correct.
And what is it, other than payment of money, that had to be done in Florida by the holdings company?
Well, pursuant to the contract, the payment of money was what it was required to do under the
All right,
contract.
but with there's case law that says that just the payment of money is insufficient to bring somebody in under that statute. The payment of money alone does not create a breach of contract to be performed in Florida. If not, every case where you've sued somebody and then they lose, they would have to pay money in Florida because the plaintiff is in Florida. So we would basically swallow the rule with the exception.
Your Honor, I think the breach of contract is the first question, whether that's sufficient to satisfy minimum
No.
contacts.
I'm saying that there's case law that says the first prong is not met if the only thing you can allege is the payment of money.
Well, Your Honor, we would cite case law that says that when there's a debt to be paid to a creditor, and that creditor is located in Florida.
Yeah, but your debt is not a promissory note, correct?
No, although it's an obligation under a contract, and we would argue it's
According to
analogous.
your version of the facts, but they dispute that they have to pay anything, and then that's why you have the suit on the merits, right?
Correct, although I would submit, Your Honor, that the appellant doesn't challenge at this point the fact that we've satisfied the first prong, and that was
No, I
evidence.
don't believe that they said that on their my questioning this morning. They
Correct.
challenged both prongs. So other than the payment of money, you admit then that there's nothing they have to do in Florida. They didn't have to come in here and perform any labor or do anything under the contract, just payment of money.
Correct. That was what they were. That was what they were obligated to do.
All right.
Counsel, let me ask you a question, because I'm still concerned about the first prong. And are you flying under the defendant's amended counterclaim?
No. What we're referring to is simply the counterclaim, which states that per the operating agreement, this is in tab 2 of the appendix, the second page. If you look at the allegations in paragraph 5 and paragraph 6 and paragraph 9, we allege in the complaint that there was money to be paid in Florida pursuant to an agreement, and that Holdings breached that agreement by failing to make that payment.
That one payment, and that's the only jurisdictional allegation as to the first prong that you have.
Correct.
And where, can you direct me exactly in the contract itself where that obligation arose?
Absolutely. If you will turn to the fifth to last page of the second tab of the appendix, there's a section 6B entitled.
Do you have numbers at the bottom? Can you direct me to?
Sure. The best way is probably just to go 5 back because the numbers are not, there's no Bates labels and they're not numbered consecutively.
Well, I have, towards the end, it says 51, 52, 53, 54. Which one is it?
Are you on the back of page tab 2, Your Honor? Of
Appellants.
Appellee's appendix.
Police, okay.
I apologize.
All right, what paragraph?
Paragraph 6B, Your Honor.
Okay. Okay.
And that
Buyout.
provision, correct, that provision deals with holdings obligations to make a payment to IRP in the event that the IRM CEO and the principal of IRP has his employment terminated for any reason. In December 2007, his employment was terminated, thereby triggering holdings obligation under that contract.
Isn't that a contingent obligation? And aren't there case law isn't there case law in Florida that says you have a contingent obligation, it's not enough to meet minimum contacts?
I'm not aware of that case law, Your Honor.
There are, but is that a contingent obligation?
Certainly, it wouldn't be triggered unless Mr. Santiago's employment was terminated, which it was, thereby vesting.
What if Mr. Santiago were stealing money from the company?
Well, Your Honor, if
You'll
you'll
have to pay.
If you look at the parenthetical on the next page, it says if he's terminated, whether by resignation, voluntary or involuntary separation of employment, or fired with or without cause, this is a anything goes termination clause, which would entitle IRP and Mr. Santiago to their rightful share of the money, which is the disputed rest in this case.
Counsel, your entire argument for affirmance as the appellee in this case rests on the argument that the requirement for payment in Florida under this buyout agreement is required to be made in Florida, correct?
That's the first prong, Your Honor. Correct.
That's the first prong.
Correct.
And it's really the only fact that you have supporting affirmance, correct?
Well, Your Honor, I would suggest that there's ample evidence in the record to support affirming Judge Freeman's order.
What other facts do you have about contacts in Florida by IRM Holdings?
IRM Holdings entered into a contract with a Florida LLC IRP, the subject matter of which is a Florida LLC IRM, which calls for payment in Florida. IRM Holdings triggered the termination event leading to that payout by engineering the coup which deposed Mr. Santiago from his position as CEO. Then,
What did they do in Florida on that subject?
well, they set into motion in a board meeting the termination which occurred in Florida. They were purposely availing
Where
themselves.
was that board meeting held?
Your Honor, the evidence in the record on that fact is unclear. It's not. The evidence doesn't.
You had the burden of coming forward with that to show Florida contacts, did you not?
That's correct, Your Honor. But I would submit that regardless of where that meeting was held, the fact that the ultimate impact of that action occurred in Florida constitutes a contact.
How do you, on the second prong, how do you square the facts of this case with International Shoe versus Washington, the lead case on point, and Worldwide Volkswagen?
Well, Your Honor, I would say that the takeaway from Worldwide Volkswagen is, did the appellant reasonably foresee being hailed into court in the state of Florida, such that since the U.S. Constitution is not violated? That standard has clearly been met here because
Well, I'm still.
IRM Holdings is a Turks and Caicos company. It has no officers. Well, it conducts no business of its own here in Florida. Correct?
That's correct in a sense, Your Honor. Its only purpose is to hold shares of IRM. It exists merely to.
So the only contract that exists is this right of payment, contact. that is a lot less in terms of minimum contacts than, say, International should go all the way back to 1947,
Well,
48, correct, or 45?
Well, I would also suggest, Your Honor, that when IRM Holdings agent Emmanuel Alexio traveled to Florida on a number of occasions, and there is record evidence to support that he is the agent of IRM Holdings, came into this jurisdiction both to manage the business of IRM and to attend board meetings and partner meetings.
So let me go back to the first one, because I'm still hung up on that. In the Lavery versus Whitney National Bank case, you have said that, of course, the payment of money is not all we have here. We have a lot more. Is that what you were referring to now, that this is the lot more, that you have one individual that is coming into the state and he's an agent of the holdings?
Correct.
How is the agency manifested?
It's manifested by Mr. Emmanuel Alexio's explicit testimony that he acts at the behest of the owner.
Well, he was one of the directors, right?
Correct, and he
So
said
we have a director in a company that is elected by the holdings company,
right.
and he comes in here and a 50-50 basis because he's one of four, and you're saying that that is basis for exercising jurisdiction over the company, even if it was an agent?
Well, I would submit that that's one factor, Your Honor.
What case supports that argument at all?
Well, I would also want to clarify. I think there's a little confusion about the percentage of which party had which members of the board of directors. Before December 2007, it was split 2 and 2 out of 4 members of the board of directors. IRP had 2 and Holdings had 2. After December 2007, where IRM Holdings kicked out the minority shareholder and took everything for itself, it held all 4 positions on the board of directors. So when a wholly owned sub, which is being 100% controlled by a parent company, sends its agent into Florida to effectuate...
What case do you have that supports the argument that by sending an agent into the state of Florida, they're subjecting themselves to the jurisdiction of the state? Assuming agency.
Your Honor, I would...
You don't have to bend over.
I'm sorry. I would cite, Your Honor, to Defense Control USA, Inc. versus Atlantis Consultants Limited Corp., which is a decision from this court from 2009. I would cite to Hatfield versus AutoNation, Inc., which is a decision from the 4th DCA of 2005. Freed versus Bergman, another 4th DCA case from 1999. And I would suggest that all of those cases hold that when a party is coming into Florida and bringing its agents into this jurisdiction, it cannot simply hide behind its shield and say, I couldn't have ever dreamed that someone would sue me. When my agent is here...
So assuming General Motors didn't sell any cars in Florida, but somehow one of their agents found themselves in the state of Florida, then we can hail them in here.
I guess that would depend on how serious the contacts between that agent and the jurisdiction were. Simply one visit might not be enough. If that agent, as in the case of Mr. Alexio, regularly traveled into the jurisdiction to attend to the business of IRM Holdings, acting as the agent, as he admits, of IRM Holdings, then I would certainly suggest that that's enough.
Thank you very much.
Thank you.
Thank you, Counsel.
1 minute.
Thank you, Your Honor. Real briefly, a couple anecdotal comments. The provisions cited in the contract, that's the basis of the counterclaim for breach of contract, does not say payment in Florida. It just says payment. Second of all, as the court pointed out in Labre, the only thing called for, even if you assume that the payment was to be made in Florida, was a single payment. Also, I would direct the court to 2 cases cited in my brief. The Kurtz case, which is a 3rd DCA case, and the Soror case, both address the issues that are being raised by the appellee with regard to the activities of a member of the board of directors. I don't believe that the appellee in this case showed in the lower court that IRM Holdings Limited exerted the sufficient amount of control over the operations day to day that is required to satisfy minimum contacts. Thank you very much.
Thank you very much.